Today, we're talking about Medicaid estate recovery with attorney Shannon Pawley of the Georgia Estate and Asset Protection Law Firm.
My name is Shannon Pawley. I am one of the attorneys and the owner of the Estate and Asset Protection Law Firm. And I'd say there's a lot of things that set us apart than other firms. Number one is I actually was the vice president of my national debt collection law firm for 16 years. So I often make the comment, if you're going to an IRS audit, who do you want with you? A former IRS agent. Well, if you're doing estate planning, who do you want with you? A former executive for a debt collection law firm that knows the tricks and the trades when it comes to asset piercing and obtaining as a creditor. But even beyond that, I'm always very proud to say that although asset preservation, of course, is something that we do, our vision is we want to live in a world where people don't lose everything, their independence, their dignity, their grace, their assets, because their mind or body starts to betray them. That's why it's so important as our mission to ensure that people's voices are preserved in their estate planning documents and strategy, so that even if they are silenced by mind or body, their independent wishes can still be followed.
I love that. Thank you for sharing about your experience and what is important to you and obviously to your firm. One of the top questions that we get is about Medicaid estate recovery. I'd love to get into sort of the nitty-gritty of it, but first, can you just sort of cover high level what is Medicaid's estate recovery and who does it affect?
Certainly. So Medicaid estate recovery, this is a requirement, not an election, that states must follow if they have a Medicaid recipient that was receiving Medicaid benefits for the purposes of the usual program. For example, here in Medicaid would be ABD or facility Medicaid, and also Medicaid in the home under the Elderly Disability Waiver Program. So the idea here is that while via eligibility, for example, you'd be eligible for Medicaid and own a home. And that home can have over $700,000 in equity, and you could still get onto Medicaid. And at first glance, a lot of people may be high-fiving, thinking, this is absolutely fabulous. Thank you, Uncle Sam. I get my cake and eat it too. But one of the things I always tell people is where the government gives, the government will take back. And here, they're giving you the opportunity to not have to sell your home during your lifetime, so that if at some point you ever were to leave that skilled nursing facility, you have a place to go back home to. But the other thing too is now Medicaid knows you have an asset. And the idea of estate recovery is a program to try to replenish the funds that are spent under the Medicaid program from the estate of the former Medicaid recipient that dies to try to repay back. Because Medicaid estate recovery at its hardest, most hurtful sting is that they're going to take back out of your estate up to the full value of benefits that they paid out over your lifetime. And that's why very often we start talking about estate recovery, we're almost always talking about houses, to be honest with you. And that's always the sting that people don't realize that the sting is coming until sometimes it's too late for strategy.
Yeah, this is the top question that we get is Medicaid going to take my house, or don't sign up for those programs, Medicaid will take your house. Awesome. I guess you're talking about estate and you're saying most often that is the home. What other assets are subject to Medicaid estate recovery? What's included in an estate? Like, can you define that word for us?
So this is where it comes to the joy of having an experienced elder law attorney that's very familiar with policy and its application and how to effectively and efficiently present it to the state's department that's handling Medicaid. But estate recovery, when is it going to apply? Well, it's going to apply, of course, after the person passes, and it officially is based upon their estate. Well, what would be part of their estate? Well, estate, in the most basic of terms, is anything that that person owns in their individual name at time of death. So, ideally, with limited exception, if it's jointly owned with another or has a pay on death beneficiary, it's not part of your estate. Now, some people may then go, well, then that's fine. If I have a home that is joint tenants with right of survivorship with my child, then boom, don't I get away from this, Attorney Pawley? Unfortunately, you don't, because the statute specifically addresses jointly held real property. But what is normally going to be affected here? Well, the first thing you got to remember is when you get onto Medicaid, you have to be below a certain resource threshold and income threshold. And so really the only thing they're going to go after are those exempt assets that you could have had an entitlement to. Now, house, yes. Cars, in my experience, I've not seen them ever go against a car. But then again, I've never had any clients that have Bentleys or Aston Martins either. So that might change that thought a little bit. Further, if, for example, you have as exempt your 401k, for example, well, it's exempt. It's no longer counts towards your resource because it's now an income stream. But if you do not have a named beneficiary in your 401k or the person you named predeceased and there's no backup, well, guess what? That 401k now gets paid over to your estate. What do we know? Anything that's in your estate is ripe to be reached by Medicaid estate recovery as a creditor. So where I make the comment, usually it's just the house we're talking about here. There could be other situations through, I'm going to call it, whether it be poor planning or unexpected planning, where pay on death beneficiaries are either not named or they predecease. And now that asset, whether it be life insurance, whether it be an investment, retirement account, may become part of the estate. And then estate recovery would be just like a standard creditor to seek their funds back.
That's super helpful. Are there instances, exemptions to the rule, instances where Medicaid is not going to recover from your estate?
Well, one of the first things I will say is if it's a husband and a wife, and let's say the house was owned jointly, and the facility spouse passes while the community spouse stays alive. Well, first of all, Medicaid is not going to come in and take away the house from the surviving spouse. They're going to not pursue it until the death of the surviving spouse. Similarly, if we're dealing with disabled children, that is another situation to where Medicaid does not immediately go out to grasp. They will postpone the collection until the passing of the disabled child. And one of the things I always emphasize is depending on how long those survivors survive after the death of the Medicaid recipient, sometimes by their continuing contributions to the house, taxes, and upkeep, all of a sudden, all that they've contributed keeps taking down that estate recovery claim until at some points, just the fact that they outlived the Medicaid recipient for 10, 20, or 30 years, by their own actions, they may have made it to where the collection under estate recovery is moot based upon their own personal investments into the home, for example.
That's helpful. For people that are considering getting Medicaid, or people that are planning, they are working with you in advance to figure out what they can do, how can families protect their home and or estates assets from Medicaid estate recovery?
Well, here's the first and easiest way to deal with, and that is we're dealing with a marital couple. Here in the state of Georgia, transfers between spouses are exempt. They don't equate out to penalties. So perhaps what we might do is have this jointly held property with husband and wife. Wife is the one that's going to go on Medicaid. Well, then fine, we're going to transfer the home out of their joint name into husband's name solely. And now the house is solely in this husband's name because that transfer doesn't equate to a penalty. Now we still have to make sure the marital couple is below the marital threshold, but that's when the strategy comes with the elder law attorneys of after we get assets into the name of the community spouse, we may then sit down and do like an interfamily promissory note or et cetera, just to try to get the funds below that threshold. And boom, we've now saved the house and most, if not all, of the marital assets. Now, another way that we could potentially have this is in the event that we're dealing with a proactive individual that does a 5-year strategy. This is where, whether it be an individual or married couple, you could do a proactive trust strategy. This is where you take that home or those highly appreciated properties, you're going to put it into an asset protection trust. Lid goes on it immediately. Just as you can no longer touch it, neither can Medicaid after 5 years. But that proactive strategy requires 5 years. Well, I do have some people that are the proactive persons. Most people are in a crisis situation and they come to me. So then what's our next thing that we look at? Well, if we don't have a marital situation, well, what we might then sit down and do is try to see if for that home, prior to going into the facility, was there a child that had been living with the parent for a minimum of 2 years before going into the facility? Well, if that has happened, well, perhaps we have the opportunity to properly claim what's called caregiver child, which is where you can take the home out of the parent's name, transfer it over to that child that has been living with the parent for 2 consecutive years immediately prior to going into the facility. and that is an exempt transfer. Another example we could do, let's say we don't have a spouse, we don't have a caregiver child, we just have, let's say, a solo senior. Well, then at that point, we are going to address the home at the time of application, and we're not going to be able to preserve all of the value of the home or the asset, but we are going to preserve somewhere between half to 2/3 of the value of the estate or assets via a sale. For example, for non-residential property, so we'll get perhaps the person confirming that they're no longer intending to reside there anymore. Well, here in the state of Georgia, it's considered to be a reasonable offer. 2/3 of fair market value is considered to be a reasonable accepted offer. So boom, maybe we might try to properly document that and go down that strategy. The biggest thing I want you to realize is there are strategies, and strategies are directly relative to your individual factual situations. And in those individual factual situations, there's different opportunities. In addition, Medicaid policy changes all the time. So what is allowed today may not be allowed tomorrow, and what's not allowed today may be allowed tomorrow. And then lastly, don't forget about the differences between states. Though Medicaid is a federal program, it is ran by the states individually. And that's why different states may have different qualification requirements and allowances. And that's why if you cross state lines, you're not automatically on Medicaid in Georgia if you were in it in Florida. You have to reapply. And sometimes what was allowed in Florida immediately disqualifies you in the state of Georgia, such as if we're dealing with a pooled special needs trust for somebody that is over the age of 65 when they did that. So all in all, with all that I stated, I'm hoping I'm giving hope and I'm giving a little bit of education of opportunity. But the biggest thing here is I'm giving you hope to seek out the counsel of an expert to solidify that hope into your own personal reality and strategy. But don't roll over and expose your belly and thinking that this is all that can happen. Medicaid state recovery is going to get everything. There's opportunity, there's hope, and there's experts like myself that are available to assist you.
Yeah, I think everything you've just said is very hopeful because I think people hear, you know, my neighbor down the street, they took her house, or my mom's friend's cousin, this terrible thing happened, they took everything, and it feels really hopeless, but that it means you're also missing out on other benefits that are available to you. I do have some follow-up questions about policy, which you mentioned. But first, you talked about caregiver child transferring to a property to a child. Are there any things that we need to know about? We mostly help family caregivers that are caring for a loved one at home. Is there anything that's unique that someone who's caring for their parent or another loved one at home needs to know about estate recovery?
So if it is a child and we're trying to preserve the house, move into the house, but you've got to support your residency here. This doesn't mean that you're going to say, well, I live there 5 days, but I own a house and I live there in 2 days. And I do take the homestead exemption for my house over there. That's not going to support caregiver child. Caregiver child, they're going to be looking at your driver's license. How long have you been reported as your primary residence? Utilities, voting cards. So realize that it goes a lot bigger than just you asserting, yep, I've lived there for 2 years as my primary residence. Now, have I had to get to the point of getting neighbors to sign affidavits because I didn't feel I had a strong enough case with governmental documents? I have, and that's a more challenging presentation, but if properly presented, that could still be successful. Now, sometimes people will say, well, you know, I don't live there, but my child, mom's grandchild's living there. Caregiver child only applies to child, not to grandchild, not to cousin, not to niece. It only applies to child. And also, as you're sitting down and you are living in the home, let's say that instead of you living with your parent, let's say that your parent moves in with you. Okay, and now we've got mom's house that nobody's living in. And you're trying to figure out how to handle that situation. Like we already know, you can own one personal residence and it's exempt and you can qualify for Medicaid, but it will be exposed for estate recovery. Well, then fine. At that point, perhaps what we might want to do is sell mom's house to a third party or to a family member. Now you have a chunk of money. Well, guess what? Mom's living in my house and we're anticipating you're staying here for a length of time. We need a ramp. Okay, let's use some of those sales proceeds from mom's house to get a ramp. Okay, we need to redo the bathroom and we need to change the computer room into a livable space with a wheelchair. Okay, fine. All that construction you're doing to try to make the environment more livable for your parent, well, utilize the sales proceeds of the home to do that. And yes, this is adding value to your home, but what we emphasize is for fair market value to make the home a more livable environment. Another big thing here is if mom's now living with you and we've sold the home, we've got, a chunk of change still sitting in the bank and you are driving a Ford Festiva, which is very difficult for mom to get in and out of, well, then what you might want to do is maybe utilize some of those funds to purchase a vehicle that is more convenient for mom to get in and out of, and utilize some of her funds to purchase that vehicle, which will, of course, be in your name so you can get insurance. But we're disclosing it to Medicaid as a vehicle is her one exempt vehicle for a primary mode of transportation. But once again, the great thing here is it's not in her name in that example. So all these things I'm stating, I don't want anybody to go out and try to do all of these on your own. These are just giving y'all guys hope and understanding here, but there are different options. Another thing, fine, we have money sitting in mom's bank account and you're not the primary caregiver, fine. Assuming you're not the spouse, let's get a professional caregiver contract drafted and you start getting paid as the caregiver for mom's estate. Now, what I say about this, a lot of times when I'm doing this with families, I always tell them you got to realize when mom's paying you, that is reportable income. So I always tell people if you're trying to utilize that money for whatever purpose, put 1/3 into an account to cover taxes. The remaining 2/3 you put in an account in the child's name. And if you choose to gratuitously pay for stuff out of that account for mom, you certainly can. But now we've got that money out of mom's estate because now she's paying you for the services you're rendering.
Awesome. That's all super helpful. And I definitely hear what you're saying. I think this is very hopeful for people to hear. You mentioned before that Medicaid policy is ever changing. It's changing state by state. I don't want to mark any of your words as the Bible right now, but as of the time of recording right now, are there any recent changes or proposed changes to Medicaid estate recovery laws or rules?
Not that I have heard, but what I will tell you, something I'm very curious about, and before I completely slaughter how to say this word, I'm going to use my friend Google to look up how to say this word. But one of the things, a lot of states on their records, they have some like really old laws. And in those old laws, I believe that it is called filial, FILIAL responsibility laws. And some states have gotten really aggressive with this. For example, Pennsylvania. But the idea here is that it basically is a law that imposes responsibility upon adult children for the support of their impoverished parents. Now, here in the state of Georgia, we have that also. But how it's currently drafted, it states that the only people that can chase it are the counties who have done some form of support, not the state. So it really has no teeth here. But if I start looking at some of our brother and sister states, and I'm seeing, for example, Pennsylvania, how this is getting much more aggressive, and I'm looking at the cutting cost and focus of our current administration, do I think that states are going to get a little bit more creative on utilizing current entitlements to try to seek reimbursement for the funds paid? I hope my crystal ball is on the fritz and is broken, while my crystal ball is telling me that we need to be very concerned about that, or at least observant of it. So when we start seeing that, so policy wise, nothing specifically, but what am I seeing in some other states like Pennsylvania? I'm seeing how the filial laws are starting to be more teeth than gumming how it is in most situations.
Yeah, that's super interesting. And I think everyone's paying a lot of attention to what might happen. In this instance, in your hypothesis, and again, we won't mark any of your words, but what does what you've just said mean for families and family caregivers? Like, is there anything they need to be paying particular attention to or planning for? Should states like Georgia get more aggressive about their filial laws?
I think that one of the first things is we've got to make sure that we have a situation where everything's being properly documented. You want to have a paper trail to support what you're doing, to support how you're supporting and how you're utilizing mom's funds. I think that secondly, I don't think that this is going to happen overnight. I think it's going to be kind of like the frog in the boiling water. We're not going to realize we're surrounded by boiling water till we're in the middle of it. But if we suddenly start seeing most vendors already, they hide in their contracts personal guarantees. But maybe that's where it's going to start. Every facility is going to require every child to sign off as a personal guarantee before they can go into a nursing home. Maybe it's going to start there. So now we're getting more accustomed to being responsible. And then it's just going to keep growing from there. But once again, I don't feel this is going to happen instantaneous. I think it's going to be the frog in the boiling water, to be honest with you. I think it's going to start with just some of the basic contract law of what's expected at these facilities and hospital or medical establishments when they're providing the care, and maybe start mandatorily requiring the guarantee of a family member, guarantee of a child, guarantee of all childs. I'm not sure.
Yeah, that's interesting. Thank you for theorizing with us. Is there anything that we've missed? I know this is, a short conversation. We're giving people sort of a flyover, but is there anything we've missed about estate recovery that you feel like is pertinent for someone to know in this 25 minutes they've been listening to us?
Well, I think number one is expect it. If you're on Medicaid at the time of your passing, expect to be contacted by Medicaid Estate Recovery. Do not ignore the letter. Respond back. And in your response, not only attach the death certificate, but summarize. If you're opening up a probate estate for your loved one, Medicaid Estate Recovery is definitely going to be very interested. But once again, if you've done your Medicaid eligibility properly, and if you've maintained their eligibility status over their life, they shouldn't have any assets putting them through probate beyond those that we've already talked about how you can proactively address, meaning those exempt assets, such like the home and etc. Lastly, I emphasize when somebody goes into a skilled nursing environment, whether in the home or a facility, assuming the person has capacity, get those powers of attorney and make sure those powers of attorney are giving you broad powers, including but not limited to the ability to change beneficiaries so that you're not caught where nobody has that power and dad predeceased mom in the nursing home, and now nobody can change the beneficiary. Now you know that investment retirement account becomes part of the state, and a state recovery can come against it.
Awesome. Yeah, that's great advice. We'll be sure to link our previous conversation about powers of attorney here. And if people would like to find you, learn more from you and your firm, I know you've put out a lot of content and education. Where can people find you?
Certainly. So you can find our website at www.elder, ELDER, law, LAW, Georgia, spelled completely out, GEORGIA.com. And when you're there, you can go to our events tab and it will give you a list of all of our upcoming weekly webinars. I do webinars every Thursday at 1:00. Topics change each week. For example, last week I was talking about special needs trust. This week I'm talking about probate. And I'm very big on education. I want an educated consumer. I don't want a naive consumer, because a naive consumer can not only be manipulated inappropriately by others, but they never truly understand that which they are doing to know how they are protecting. And I don't want someone to wake up in the middle of the night pondering, what did I do and why did I do it? I want you to always have the answers so you can sleep well at night.
Certainly. I love that. Thank you so much, Attorney Pawley, for joining us again. This has been very educational. We'll be sure to link you all over the place so people know where to find you.
Thank you so much, Katie. You have a great day, okay?